The next case on the call of the docket is agenda number 15, number 126675, Mancini Law Group versus Schaumburg Police Department. Mr. Burdett?
May it please the court, Josh Burdett on behalf of plaintiff appellant Mancini Law Group. A little over 20 years ago in Lieber, this court held that selective disclosure by the government is offensive to the purposes of FOIA and intolerable as a matter of policy. Preferential treatment of one group over another creates exactly the distrust of government that FOIA was intended to eliminate. If records can be produced to one party, then there's no valid basis to withhold them from another. There's no question that here, in this case, plaintiff was able to pay $13 to LexisNexis to get unredacted reports. SPD's response is to basically say that Lieber is no longer good law or doesn't apply. They throw a whole slew of arguments at that. Their core claim is that the General Assembly intended to overturn Lieber when it amended FOIA in 2010. They cite nothing in the legislative history or any other source that supports that claim.
Counsel, does the police department have to use LexisNexis in order to fulfill their responsibility to the Secretary of State? There are three alternatives, aren't there?
Yes, that's
and
correct.
Does that make a difference?
Yeah, they don't have to use LexisNexis at all. If they wanted to, they could report directly to the state with no middleman. There's no requirement for any production at all to Lexis. And they made a production of unredacted records to LexisNexis free of restrictions as to what Lexis may do with them and allowing LexisNexis to resell them. And that can be seen in the contract between them.
But they have a statutory obligation to disclose that information to the Secretary of State, is that correct?
To the state, yes.
And does that make any difference in your analysis of whether it's like Lieber?
No, it doesn't change for the waiver purposes because they could just produce directly to the state. They could, without using Lexis at all, if they wanted to use a middleman, they could say, here are the records, but you're not allowed to disclose them without redacting this information. But there were no restrictions in that agreement. They made the agreement restriction-free, and in fact, that contract between them explicitly contemplates LexisNexis selling the reports. So they point to this language, and specifically, what do they specifically talk about? They point to the language in section 7.1 when they talk about the FOIA amendments of 2010. And the post-amendment language actually decreases public bodies' discretion and increases their disclosure obligations. It says that a public body can't withhold an entire record just because there's an exempt piece of information in it. You have to redact the exempt information, produce the rest. So if there's a 5 or 10 page record and it has one piece of exempt information in it, you can't say you don't get the whole record. You just redact that one piece and then they have to produce the rest. In other words, 7.1 is eliminating that opportunity for gamesmanship that by public bodies. And that just doesn't aid SPD's position at all. And it certainly doesn't overturn Lieber.
May I ask you this? The question here, one of the questions here is that the police department was required to transmit all this information to the Secretary of State. What information is required under the statute to be turned over? In other words, we have here some private information, personal information that's at issue here. Not information necessarily about the police department itself, but personal information of people who have been involved in automobile accidents. Is all of the information here, the home address, the home phone number, et cetera, is that all required to be turned over to the Secretary of State?
I believe so, Your Honor.
And then can I just follow up with that question?
Sure.
And I know this is a little off, but the statute talks about this personal information. When personal information is contained in public records, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy unless the disclosure is consented to in writing by the individual subjects of the information. We haven't had much discussion here about the individuals' phone numbers and other private information. Clearly, they did not consent to have their personal information disclosed. Do they retain any privacy rights?
No, so the issue here is that all this information is already freely obtainable by the public. The only thing is you have to go to LexisNexis and pay to get the records. But it's all this information's already out there. That's the point of the waiver argument. Similarly, the fact that information in the reports has to be produced to the state doesn't impact the fact that waiver occurred. We're not saying that waiver occurred because of production to the state. It's the fact that this was produced to LexisNexis. LexisNexis didn't even have to be used, but it was given to LexisNexis free of redactions, free of restrictions, with the allowing them explicitly to resell.
Is the problem because it was transmitted to LexisNexis, or is it your position that because it was disclosed even to the Secretary of State that it becomes available?
No, the waiver, we don't argue that waiver occurred because of the production to the state. The waiver occurred because of the production to a third-party reseller, free of restrictions, allowing the third-party reseller to sell government records at a profit.
But those entities are authorized by the state, is that correct, in the legislation?
They're allowed to use LexisNexis as a middleman, that's correct. That doesn't allow them to produce the records to LexisNexis and let them go out and sell the records to whoever's willing to pay for them, and selling them more than what the public body is. The appellate court's ruling has created a regime where there's two classes of people: those who are willing to pay for exempt information or exempt records to get them, and those who are not willing or are unable to pay for them. And that type of preferential treatment is exactly what Lieber exists to eliminate.
Well, the city can release it to and charge for it, can't they?
So the city released the report subject to redactions, and
Right.
they can only charge $5 under the vehicle code.
Does it make any difference if other police departments act similarly to Schaumburg? In other words, other entities do the same thing?
No, that wouldn't affect anything. Perhaps there are other police departments that are waiving their rights as well. I don't know. That's not part of the case at all.
Okay, thank you.
Council, under this arrangement with LexisNexis, the police department is getting the same amount for purchasers to Lexis as they would get if they were just releasing the information on their own. Is that correct?
That's correct. But LexisNexis is charging more than that amount. So Schaumburg Police Department could only charge and receive $5, but LexisNexis is going beyond that, charging $13. And you could imagine a world where if the waiver rule was done away with, then any set of records, whatever they may be, could be prison records related to prisoners, test questions, police reports, trade secrets, whatever it might be, the records could potentially then be sold for a profit by a third-party reseller.
Counsel, does the contract itself restrict secondary disclosure when it uses the phrase "in compliance with applicable laws"?
So that's what SPD's position is. They claim that LexisNexis has to comply with FOIA, and the only thing they can point to is that one piece of umbrella language. And it certainly doesn't force LexisNexis to do anything. So first of all, LexisNexis is not a public body, so FOIA doesn't apply to them, and that's the really simple answer. But even if you go further, FOIA exemptions are optional. So even if the exemptions applied, Lexis is subject to FOIA, Lexis doesn't have to assert the exemptions, Lexis doesn't have to redact anything, even if it was subject to FOIA.
So this contract would be okay if it said, must be redacted pursuant to FOIA regulations or something to that effect?
If SPD required redaction in the contract, then yes. But even if the contract said and could say that Lexus is subject to FOIA, which it can't even be subject to FOIA because it's not a public body, but there's no requirement to redact anything at all because exemptions are optional. A public body may elect to redact exempt information, but it's not required to. So we've touched on their core claim about Section 7.1 and the 2010 amendments. They have a number of others as well. They argue that adding Section 2C5 to clarify what private information is somehow overrules the waiver principle in Lieber. They argue that 2C5 lets public bodies withhold addresses. But that misses the point entirely, because waiver can only apply when material is already exempt. So the question of whether information is exempt or not is irrelevant when discussing waiver. And to the extent relevant, Lieber actually said that even if addresses were exempt, waiver would still require disclosure. Another argument SPD makes is their claim that waiver doesn't make sense because 7.1c contains a waiver provision. Well, destroying that claim is the fact that the consent language they rely on was part of the statute prior to Lieber and remains unchanged in the 2010 amendments. And plus, 7.1c doesn't even contain a waiver clause at all. It provides for release through consent. In other words, all 7.1c is doing is codifying common sense. Something can't be an invasion of personal privacy if the person themselves consents to the disclosure.
And just back to my question. Did these individuals consent to the disclosure?
That's not part of the record, but it looks like the answer is they haven't been contacted would be seemingly the most likely answer. It's similar, I mean, this case in some ways is similar to Lieber. Lieber, the underlying issue was a university disclosing addresses of college freshmen originally to everybody who wanted it so that they could market to the freshmen about housing. And then what happened was the university started just disclosing the addresses to only certain groups and not to the plaintiff in the case. And the court said, you can't do that. You can't have that type of preferential treatment. And it's actually very similar because, as far as the record shows in that case, there was no talking to the individuals about consenting to the disclosure of addresses. It was about marketing to people by sending them mail to their address. And that's very similar to what's happening in this case. So we touched on the 7.1c claim. SPD also claims that Lieber dealt with a different exemption than the one in this case, so it can't apply. But again, we aren't talking about the scope of exemptions. The only question is whether SPD waived its right to assert exemptions. Lieber cited for the legal principle of waiver, not a discussion of the scope of the specific exemption. SPD also mischaracterizes our position by saying that under this interpretation, producing a record to a victim of an accident entitles the whole world to the report. And we've never said that, and we've never said that producing the report to the state constitutes waiver. It's true that privacy considerations are different when people request records about themselves. Our position has always been from the beginning that releasing reports to a third-party reseller with no restrictions on what that third-party reseller can do with the reports and no redactions to those records, that's what constitutes waiver. All of SPD's claims about the 2010 amendments overturning Lieber are gutted by basic principles of statutory interpretation. If the General Assembly wanted to eliminate the Lieber waiver rule, then they would have done so expressly. They would have done it clearly. They definitely wouldn't have done it in the incredibly ambiguous way that SPD's arguing for, where waiver's never discussed, the word never even comes up. And as this court has held, there's a policy against overturning cases by implication. And that's what SPD is asking this court to do here.
Counsel, when you say there were no redactions, are you relying on the Camerata affidavit for entry of summary judgment in your favor as it relates to that?
In part, and there's been no dispute in this case that the reports are produced to LexisNexis unredacted.
Right, but we don't know how they're then disclosed by LexisNexis to others, other than this affidavit.
Yes, the affidavit from Camerata, which says that he's obtained multiple different reports over the years, free of redactions. And if Your Honor's getting at a question of fact remaining, then that would be a reason to remand to the trial court for exploration of that issue of fact.
How do you explain the appellate court majority's treatment of that affidavit?
Could you be a little bit more specific?
Well, I mean, it's somewhat confusing to me as how the appellate court majority looked at that affidavit. I mean, Justice Hyman certainly gave it some weight, and the appellate court majority discussed it, but didn't really tell us what they were doing with it, and then, ruled against you. So, I don't know.
Yeah, I had a very similar feeling when I looked at it as well, and it was a bit strange. The appellate court said that the Camerata affidavit failed to explicitly state that he wasn't representing the people that he was requesting the accident reports for. I mean, if that was a turning point, then that would be an issue of fact easily resolved on remand. But it doesn't seem that there's any need to do that. The primary issue at the trial court and the appellate court level on that point was they characterized it as SPD being absolutely required to send the reports to LexisNexis. But of course, that's not the case. They're required to send them to the state, and they don't have to use a middleman at all. SPD has conceded they don't have to use a middleman. They've conceded they don't have to use LexisNexis. And so they've at least tacitly conceded that there's no mandatory obligation to produce the reports to LexisNexis. So there's no need to reach legislative history here, but that history only further supports plaintiff. As one side point, it's not directly relevant, Speaker Madigan explicitly stated that the intent to modify the personal privacy exemption was only to increase disclosure, which was a recurring theme in these amendments, increasing disclosure, reducing opportunities for gamesmanship by public bodies. Now, the real point in the legislative history, the most compelling point, was the senators discussed if they were overturning FOIA cases, and Lieber wasn't even mentioned. As one senator said, there was no intent to overturn any existing FOIA decisions. I'll just make one last point as I see I am running low on time. SPD now claims that waiver can only apply when records are produced in response to a FOIA request. And that just misconstrues Lieber, because Lieber doesn't say that at all. What Lieber says is voluntary disclosure in one situation can preclude later claims that records are exempt from release to someone else. It's not limited to FOIA. And it seems clear that when you look at the case, the disclosures resulting in waiver in Lieber weren't a result of FOIA requests. And that's equally true of the cases that the court cited there, the Cooper case, the North Dakota case. Those disclosures that resulted in waiver weren't made in response to FOIA requests. The same is true with Watkins, which is discussed in the briefing. And for these reasons, the appellate court should be reversed, and it should be found that SPD waived its right to withhold the records from disclosure. Thank you.
Thank you, Mr. Burdett. Ms. Maluzzi?
May it please the court. My name is Mallory Maluzzi, and I represent the defendant appellee in this matter, Schaumburg Police Department. This case asks this court to answer a simple question: whether the police department has waived its right to assert these proper FOIA exemptions by producing unredacted copies of accident reports to LexisNexis as part of its statutory obligation under the Illinois Vehicle Code. The simple answer is no. Plaintiff primarily relies on the 1997 decision of Lieber versus Board of Trustees of Southern Illinois University and its waiver rule, but there are two primary reasons why waiver does not apply. First, Lieber was legislatively overturned by the 2010 FOIA amendments. And second, even if waivers were found to still apply, Lieber is distinguishable from this case primarily as LexisNexis does not receive preferential treatment and only receives these records because they are a third-party vendor of the Secretary of State. I wanted to address some of plaintiff's counsel's arguments as to what the record actually states about LexisNexis's disclosure of accident reports to third parties and their relationship with SPD. It does not matter that the police department can meet its statutory obligations in another way. It is undisputed that the only reason the SPD provides LexisNexis with these accident reports is to comply with reporting requirements of the Vehicle Code, and there is no other furnishing of unredacted reports to them other than the mandatory reporting requirement. Thus, there is no preferential or selective treatment like in Lieber, where the university gave records to some parties, such as newspaper and religious organizations, but refused to give them to the housing entities. These are not in the public domain, but are managed on a server and only accessible to limited individuals in privacy agreements. I also want to point out that when LexisNexis, in its capacity as a private entity, wants to access accident reports or other records, they cannot just go in and pull out these accident reports and use them for their own personal purposes. They have to act like any other commercial entity and either pay for them using the server, because sometimes they work on behalf of insurance companies, or they submit a FOIA request to the police department and receive records redacted. So they're not getting preferential treatment for third party. Also, Mancini's argument that LexisNexis is free and unrestricted to sell accident reports to the public is just wrong and unsupported by the evidence in the record. The evidence in the record clearly shows that the agreement between the parties restricts any reselling to be in compliance with all laws and regulations. This includes FOIA and it includes the Drivers Protection Privacy Act, which has additional restrictions on production of vehicle information.
Does FOIA apply to LexisNexis?
Yes, it is often that governmental entities contract with third parties and can make them comply with FOIA.
Well, but does the agreement say that? I mean, the agreement is kind of generic. It just says in compliance with applicable laws. And so if LexisNexis has this information and they can only release it in compliance with applicable laws, is it the law that applies to LexisNexis or the law that applies to the Schaumburg Police Department?
It would be including the laws that apply to the Schaumburg Police Department. And this is shown when you look at the testimony of Ms. Brack and how she testifies that SPD has specifically instructed LexisNexis to place limitations on who can access the police reports. They cannot be accessed to the general public. They can only be accessed to those individuals who have specific information about the accident. The intent is that parties who are personally involved, victims, attorneys for the people in the accidents, and insurance companies can get these unredacted, but anyone else would either not be able to purchase them on LexisNexis at all, or would have to get a redacted copy.
Does the Camerata affidavit contradict Brack's testimony?
It does not, because notably, as noted by the appellate court decision, the Camerata affidavit does not include anything about the information that Mr. Camerata provided to get unredacted copies. Mancini Law Group represents victims of accidents. So we have no information if he provided information about his own client to get these. It said it was for a legal purpose, and I can't believe that they wouldn't put in there that they had no information about this random accident in Schaumburg and got these unredacted. They would have put that in there if that was applicable, and it was their burden to do so. Waiver, the burden of waiver is on the plaintiff. They did not meet their burden, and nothing in that affidavit contradicts Ms. Breck's testimony to state that Mr. Camarada didn't provide that information when he got those unredacted reports. I don't think that rises to a level of, or creates an issue of material fact. So for those reasons, this case is very distinguishable from the situation in Lieber with this preferential and selective treatment. Federal case law is wholly inapplicable in this matter. The Watkins case cited in the dissent and relied on by the plaintiff was decided in 2013, was never considered by Lieber, and was this whole idea of no strings attached there, you're having the requester or recipient of records sign a non-disclosure agreement, was actually called into question by this case cited by Lieber, the State of North Dakota X. Rel. Olson case, doubted whether government can bind the public and foreclose them from exercising their rights under FOIA or other acts. If this court were to look to federal case law on waiver, it should look to Illinois federal courts, which utilize the public domain theory. And as I've shown, this is not freely available in the public domain for the public. It's further not practical in application, as a public body would have to have a requester sign a non-disclosure agreement every time they wanted to give them their own records. And moreover, federal case law should not be used in this respect because the federal FOIA statute and Illinois FOIA statute are no longer the same. And when the legislature has declined to adopt certain sections of federal FOIA, it evidences an intent to achieve a different result than federal court decisions. Lieber was decided in 1997. In 2010, FOIA was amended, and it specifically added the language that the public body may elect to redact information that is exempt. This language was not included or not present when Lieber was decided. Thus, this court must assume that the legislature intended to change the law. It doesn't matter that Lieber wasn't discussed in the legislative history. That's not a requirement. In fact, we can see that part of Lieber was expressly overturned by the 2010 amendments. Lieber held that home addresses were not exempt. In 2010, the legislature added home addresses to the specific definition of private information under Section 2C5 of FOIA, making them explicitly exempt. That was an overturn of the decision in Lieber, because now home addresses are explicitly exempt. So we can already see that just because they didn't call out Lieber in the decision, there was some overturning. No court has found waiver to have applied since the 2010 amendments. One appellate court has found that Lieber involves statutory language that is no longer in effect and was decided in an era when privacy expectations were different. Waiver doesn't need to be discussed because waiver has never been in the statutory language of FOIA. It was not in the statutory language in '97 when Lieber was decided. And adding the ability to treat FOIA exemptions on a discretionary basis is the antithesis of waiver. Counsel even said FOIA redactions are optional. They're discretionary. So how can a public body know? Why would it make sense to let a public body use this discretion, use this authority, and treat requesters differently and allow some information out if doing so would forever waive its ability to redact that information in the future? FOIA should not be interpreted so as to create an absurd result. I do think that if waiver were to apply here, a victim could not receive their own records because you were treating people differently, and that is what the plaintiff said in their opening statement, is that providing records to one person, one party, with provides no valid basis to withhold them from others. So if you're going to treat a victim differently than the general public, then you are arguably waiving your ability to assert those exemptions in the future. I wanted to make one other point about some of the differences of waiver, of how Lieber is also different. Lieber involved Section 7.1c of FOIA, which is the unwarranted invasion of personal privacy, and involved this balancing test between privacy interests of an individual and the interests of public disclosure. This case involves Section 7.1b, which relates to a specific statutory definition of private information. There's a definition, it lists out everything that's exempt, and you don't have to do any balancing test. The claim that it only relies on Lieber for the discussion of the exemption for the waiver standard and not the exemptions doesn't hold water. You can't separate the two because the Lieber court specifically discussed how the privacy interests of those students weren't there given that the university had released them out to the public. So these are inextricably intertwined together, and they found waiver applicable because of that balancing test in Section 7.1c.
Can I ask you a
Yes.
back question for the record? You say that this information, all of the information, is available to some people if they are in a certain position. They're the person, they act themselves, they're a lawyer, or they're an insurance company.
Yes.
Where does that come from? Is that statutory? Where is that?
I don't believe that's statutory. I believe it is just part of it is statutory because the parties of accident reports are entitled under the Vehicle Code to get copies of their accident reports. That's in the Vehicle Code statute. And I believe that the interpretation of that has extended to their representatives as well. So, and additionally, again, the discretionary language in FOIA allows a public body to, that they may redact information, but they don't have to. So public bodies have found that those persons involved or representing them would have a right to an unredacted report. If there are no additional questions, I would say in conclusion that this court should uphold the circuit court and appellate court's decisions that the plaintiff is not entitled to the private information at issue, either by finding that waiver rule no longer applies or by determining that the waiver rule does not apply in this case. Thank you for your time.
Thank you, Ms. Maluzzi. Mr. Burdett?
So we heard counsel discuss FOIA apply to LexisNexis. And once again, public body is a defined term in the statute, and LexisNexis is not a public body. FOIA does not apply to Lexis. Also, in addition to that point, another point, we heard SPD agree that there's no requirement to redact anything at all, even if FOIA applied to LexisNexis. The FOIA statute just doesn't require redactions. Even when exemptions apply, applying them is optional. So as we've said, there's no need to reach federal case law because Lieber is already clear. But federal case law just further supports our position. In particular, the Watkins v. CBP case further supports our position. Similar to this case, CBP is required to produce notices of seizure to trademark owners. CBP placed no restrictions on the trademark owner's use of those notices, and the owner was free to do whatever they wanted with them. Give it to his lawyers, give it to business affiliates, the media, could really do anything they wanted. And there the court found that no strings attached disclosure voids any claim to confidentiality and constitutes a waiver of the exemption. And that was true even though CBP was required to produce the notices of seizure. That's just like this case here. SPD is statutorily required to produce the records to the state and of its own accord decided to use LexisNexis to perform that function. But like we mentioned, there's no restrictions on what Lexus can do with those unredacted reports. And that's evidenced in the contract between them and the Camerata affidavit.
Does it make any difference what the plaintiff wants these for?
No. It makes no difference at all that it's for a commercial request or any other purpose, and there's never been any argument by SPD that the purpose of the request is relevant.
So the request is not like the law firm represents a victim or a person that was injured in an accident or something like that. There doesn't have to be any showing of connection to any particular accident.
That's right. No, there needs to be no connection at all. And it just happened, this case happens to be similar to Lieber in the fact that the addresses are sought for the purposes of marketing. We heard a reference to a public domain argument. Well, that is raised for the first time in the entirety of this case now before the Supreme Court and can be dismissed for that reason alone. But just to be clear, for records to be disclosable under the public domain theory, the specific information sought must have already been disclosed and preserved in a permanent public record. In other words, under that theory, public bodies can produce records to one party and withhold them from another. That's exactly what Lieber sought to prevent. That's just eliminating the Lieber rule. And again, they're raising this argument now for the first time before the Supreme Court, so it can be dismissed for that reason alone. We heard more reference to a victim receiving their own records. As we've said, the privacy considerations are different when a person is requesting records about themselves. That does not constitute waiver. The exemptions contemplate people consenting to disclosure of their own records, which is common sense. We also heard, again, a reference to Lieber being restricted to just one exemption, that waiver can only apply into this one exemption, this one context, and it doesn't apply to any of the other exemptions in the statute, and it doesn't apply to essentially the majority of FOIA. And that's just not what this court held in Lieber. In Lieber, this court held that preferential treatment of one group over another, producing records to one group or party and not another, goes against the basic principles of FOIA and is intolerable as a matter of policy. That was the entire point, and it was in no way cabined to only this one narrow exemption as they asked for.
In Lieber, the information that was at issue was not confidential information, correct?
It was addresses, so it was very similar to here because that's what's sought here is addresses.
From what I can tell, and I've certainly not done enough research, but what I can tell from the motor vehicle code, the reporting requirement is that all required written motor vehicle accident reports be reported and shall be for the confidential use of the Department and the Secretary of State. And then it sets out a few exceptions for that. But the entire reporting process is to send the reports to the department and to be held for confidential use of the department.
So it sounds
somewhat
like
different. It seems to me there's nothing that would suggest that the university had some kind of confidentiality issue with these addresses. These records are supposed to be confidential. That's the word they use.
That's not the case. So 2 points. One, SPD has never, in the entirety of this case, asserted Section 7(1)A and that the records can't be produced because of the vehicle code. So that argument has been waived at the outset. But to address the substance regardless, the vehicle code actually supports us. It affirmatively supports disclosure. So when you look at that vehicle code provision that I believe the appellate court just referenced in a footnote, what you see is that goes to 412 of the vehicle code that says the reports of IDOT are confidential. And when you go to 408 of the vehicle code, it says the reports of law enforcement agencies, SPD is a law enforcement agency, are not confidential. Not only are the reports not confidential, but it explicitly states that the information contained therein is not confidential either. And then, in other sections, the vehicle code goes on to contemplate the logistics of the reports being disclosed. So it contemplates, charging $5 for most accident reports, and in certain situations, charging more, charging $20 in rare circumstances. So the vehicle code, again, this argument, the short answer is they never asserted 7.1a. They never made this argument. It's simply not at issue in this case. But the vehicle code does actually support us when you look at it. And if there are no further questions, then we would ask that this court uphold the ruling in Lieber, that the appellate court be reversed, and that it be found that SPD waived the right to withhold these records, and they must be produced. The principles underlying FOIA and against preferential treatment should be upheld. Thank you very much.
Thank you, Mr. Boudet. Case number 126675, Mancini Law Group PC versus Schaumburg Police Department will be taken under advisement as agenda number 15. Thank you, Ms. Maluzzi, for your argument this morning, and Mr. Boudet.